Hello everyone, welcome to Strive HIS. In this video series, we will be discussing about the past 1 to 1.5 years of current affairs, the topics and their backgrounds. The series will provide for detailed, crisp analysis done by the subject experts that will help you excel in your 2025 prelims. Today, we have the 6th lecture of Polity Current Affairs. Let us begin. Today, we start with the minorities / marginalized and related issues. The first subtopic for today is NALSA, but since we have already covered this NALSA in the previous classes, so we'll begin with the next subtopic. Caste-based reservation. So there are some judicial pronouncements related to the caste reservation. So first of all is Indra Soni and others versus Union of India case 1992. It was a 9-judge bench of the Supreme Court. So what was important about this particular case is that it set a 50% ceiling on reservation under the Article 16(4). So there can be only 50% of reservation for all categories. For exceeding reservation beyond 50%, extraordinary circumstances should exist. Can you please mute? Okay, so court introduced the concept of creamy layer. So another part is, they put the 50% cap. Secondly, they introduced the creamy layer, which is called as the socio-economically advanced among backward classes, who must be excluded from the benefits of reservation. Then there was the M. Nagaraj versus Union of India case, wherein the Supreme Court laid down 3 conditions that states had to meet before providing reservations in promotions. First of all, it was a quantifiable data on the backwardness of SCs and STs, then facts about their inadequate representation in public employment, and justification in favor of maintaining overall administrative efficiency. Then there was the Jarnail Singh and others versus Lakshmi Narayan Gupta and others. The Supreme Court did away with the requirement of collecting quantifiable data showing the backwardness of. So this, in the Nagaraj case, wherein the Supreme Court had said that you needed quantifiable data. Okay, so you needed data to prove the backwardness of the SCs and STs. So this was done away with the Jarnail Singh case. Then there was the Janhit Abhiyan versus Union of India, wherein the Supreme Court upheld the 103rd Constitution Amendment Act, which provided EWS reservation, which is economically weaker section reservation. Okay, so this was based on economic criteria. All this while we have social criteria. Okay, so one question for you. Which case introduced the creamy layer? So what is the, was it the Nagaraj case or the Indra Sone? Yes. Or was it Jarnail Singh case? Or Janhit? Abhiyan case? Yes, anyone would like to answer? Which case introduced the creamy layer criteria? Yes, anybody?
Option B.
Yes. Okay, the Indra Soni case. Very good. So these form the important parts. Okay, what else you can do is you can study about the National Commission for Backward Classes and the differences between the reservations. Okay, so SC, ST, OBC and EWS. The next subtopic for today is other backward classes, OBC list. So why was it in the news? Because the National Commission for Backward Classes, NCBC, is reviewing the state list of other backward classes using powers granted under the 102nd Constitutional Amendment Act. So what is this OBC and the OBC list? So there is no standard definition of OBC in the Indian Constitution. Okay, this is important. Socially and educationally backward classes, SEBCs, are commonly known as other backward classes. So what is the OBC list then? For each state, there are two OBC lists. One at the central level for benefits by the central government initiatives, and another at the state level for benefits by the state government initiatives. So the central OBC list is Article 342A, Clause 1 of the Constitution, authorized by the President in consultation of the Governor of the state to specify central list of the OBCs in relation to a particular state or union territory. Okay, so any modification to this central list can be done only by the Parliament. Fair enough. Whereas the state list, Article 342, Clause 3, empowers every state or union territory to prepare and maintain for its own purposes a list of SEBC, which is the social and economically backward classes, which may be different from the central list. Okay, so any modification can be done by the state over here. So what are the reservations for OBCs? Article 15 and 16 of the Constitution enable reservation for OBC in admission to educational institutions and in public employment. In 1990, the center implemented the 27% reservation of OBCs in education and employment as recommended by the Mandal Commission. Okay, such OBC reservation was upheld by the Indira Sawhney versus Union of India case. Okay, the reservation for OBC was upheld, but they put a cap of 50% and also introduced the concept of creamy layer. So people who are already well benefited with the reservation should now be taken out of it. Okay, so we have the Mandal Commission for OBCs. So before that, the president had constituted the Kalekar Commission, okay, to investigate the conditions of OBC. But the recommendations of Kalekar Commission were never implemented. So if you get a question that Mandal Commission was the first commission for OBC, so that is not true. Before that, we had the Kalekar Commission. Okay, so the president appoints this under the Article 340, wherein the president may by order appoint to investigate the conditions of socially and economically backward classes and to make recommendations. Okay, so this appointment is done under this article. Then in 2017, the president has appointed a Justice Rohini Commission to examine the subcategorization of OBC caste group to ensure more equitable distribution of reservation benefits. Okay, so they were supposed to give the report by 2023, but it is still not implemented. Okay, now about the NCBC. It is a constitutional body. Like we saw, the 102nd Constitution Amendment gave birth to NCBC under the Article 338B. So Article 338B mandates union and every state government to consult the NCBC on all major policy matters affecting the OBCs. So what is the composition of NCBC? They have a chairperson, a vice chairperson, and 3 other members appointed by the president. Okay, the service conditions are also determined by the president. And the commission has powers of a civil court. So what are the duties? Basically everything regarding with the OBCs, they have the same duty. Okay, so what is important for you guys over here is this particular fact that we had 2 commissions. Okay, Justice Rohini Commission also. And the NCBC. Okay, let us now move on to the next subtopic. Article 341. So what is the Article 341? Article 341 is about scheduled castes classification. Okay, so president can officially designate certain groups as scheduled castes after consulting the governor for specific states or union territories. Okay, so groups who are designated as SCs can be done only by the president. Okay, so the Supreme Court has stated that the state can't alter the SC list published under the Article 341. So this is important. So the states cannot alter the list, only the president. By president we mean the parliament. Okay, so why was this in news? Because the Supreme Court has quashed a Bihar government notification from 2015, wherein the Bihar government had considered the Tantwa community. Okay, they had considered them as SCs. Okay, so the court said that they were backward classes. So the court said that this is not your jurisdiction, so it is, hence the notification will be nullified, and only parliament has the authority to amend the SC list through legislation, not state governments. Okay, so who has the authority? Who has the final authority? The parliament and the president, basically. Okay, next subtopic is subclassification of scheduled castes. The Supreme Court's 7-judge constitution bench ruled that subclassification within SCs is permissible for equitable reservation distribution. So earlier in the E.V. Chinnaya versus the state of Andhra Pradesh, the SC had said that, the Supreme Court had said that SCs were a homogeneous group and they cannot be further subclassified. Okay, so basically they have overturned their own judgment. Okay, so what are the key highlights? The court emphasized that affirmative action must ensure fairness, and some SC groups face greater deprivation than others. Okay, so in SC groups also there are different levels of deprivation. Okay, so this is important for prelims in terms of this question. Okay, let us take this question for example. Which ruling said that SCs are homogeneous and can't be further sub-classified? Okay, so your options are Indrasoni case, E.V. Chinnaya case, Jarnail Singh case, and Nagaraj case. Yes, anyone? What is the correct answer? Which case had said that SCs are a homogeneous community and they cannot be further classified? Which case? Anybody? Sorry? It was E.V. Chinnaya case, right?
Yes, ma'am.
Okay. So E.V. Chinnaya case had said that SCs were homogeneous. Okay. But now the Supreme Court has overturned this. Okay. So this is no more true now. Okay. So now they have given the permission for equitable reservation. So now you can further classify them. Okay. Next topic is anticipatory bail under SC/ST Act. Okay, the Supreme Court has ruled that anticipatory bail under the SC/ST Prevention of Atrocities Act can only be granted if prima facie evidence of caste-based offense is lacking. So actually, what is meant by anticipatory? First, we'll deal with that. Anticipatory bail is pre-arrest bail. Okay, what is meant by that? So it is a legal provision. Okay, it is legal in India, wherein an accused person can apply for bail before being arrested. But this anticipatory bail is actually banned in this act. Okay, the SCST Prevention of Atrocities Act, the section 18. Okay, the section 18 of the SCST Act bars anticipatory bail. But what the Supreme Court has said, that anticipatory bail can be granted, okay, only if prima facie evidence of caste based offenses lacking. मतलब prima facie मतलब on the face of it. Okay, SCST Prevention of Atrocities Act is basically, to prevent the caste based offenses. But sometimes there are some false cases also, false accusations and all are there. So if it looks like a false accusation, then you can apply for anticipatory bail. Okay, but the burden of proof lies on the accused to demonstrate the absence of prima facie case before seeking the anticipatory bail. So burden of proof is lying on the accused. Now whoever is applying for the anticipatory bail, they have to show that the offense was actually not caste based. Okay, so which section of the act restricts anticipatory bail? It is section 18 of the SCST's Prevention of Atrocities Act. Okay, so what is important here, guys? The Atrocities Act. Okay, the key provisions. Next subtopic is AMU's minority status restored. So the Aligarh Muslim University. So the Supreme Court has overturned its earlier ruling from the S. Aziz Basha versus Union of India 1967 case, restoring the AMU status as minority. So in this case, the minority status was removed. Okay, but now again the AMU is a minority institution. So why? In 2006, the Allahabad court had struck down AMU's minority status, citing it as a central university established by a legislation of AMU Act in 1920. Okay, but the Supreme Court has now ruled that minority status does not depend on administrative control. So it can be brought in by a legislation, but the founding principles, okay, the founding principles were actually, it was a minority based institution. Hence, it will always be minority based institution. Okay, so under what article is this possible? Article 30, clause 1 of the Constitution. Okay, so which article is okay, which article for minorities to establish and administer educational institutions? Okay. Article 25, Article 26, Article 29, or Article 30? Yes, what is the right answer for this? Yes, anybody?
At Article 26.
Article 30, no? For um, administration and establishment of minority educational institutions. It is Article 30, okay? Okay. So what is important here, other than this, is the difference between religious versus linguistic minorities. Okay. And the constitutional basis for this. Okay. The next subtopic is atrocities against the scheduled caste. So some issues have been highlighted, that a there is an ineffective enforcement of laws like the SCST Act and manual scavenging prohibition, because there are some low fund utilization, there is educational disparity, and manual scavenging still exists. Okay, so this is basically on the atrocities against the scheduled castes. What is important here? Again, the SCST Act. Okay, and we also discussed the landmark cases. Okay, their reservation criteria and everything. We talked about the act, SCSC Act, restricting the anticipatory bail, right? Under what section was that? Anyone who remembers? Section 18. Okay, make sure that you revise this. Okay, the next subtopic is panel for equitable distribution of benefits among SCs. The central government has set up a committee under the cabinet secretary to formulate a methodology for equitable distribution of benefits among the SCs. We saw this, right? The Chinaya case had first said that they cannot be subdivided, but now they can be subdivided. Okay, so for that, the government has taken up a committee now. So, what are the key objectives? Ensure fair distribution of government schemes and welfare benefits across the 1200 plus SC subgroups. Okay, address concerns that certain advanced SC communities are monopolizing reservation benefits, but it does not address reservation subcategories directly, but focuses on equitable allocation of development. Okay, so what are the legal background of SC subcategorization? First of all, we did the EV Chinaya case, wherein the SC had ruled that SCs cannot be subcategorized. Okay, as it violates 341, wherein it is the president's power to specify SCs, right? Okay, this also we did. But the state of Punjab versus Davinder Singh, now this is a very important case, has allowed state level subcategorization of SC benefits. Okay, again the Jarnail Singh versus Lakshmi Narayan Gupta, it upheld the creamy layer which was already given in the Indira Sawhney case. Okay, so one question for you. Which case has now allowed subcategorization within SC reservations? Okay, first is state of Punjab versus Davinder Singh. Second is the Chinaya case. Third is Indira Sawhney. What is the Keswananda Bharti case? Yes? Anyone? Which case has now allowed subcategorization of SCs? What is the correct answer?
Option A, madam.
Option A. Very good. Okay, State of Punjab versus Davinder Singh. Very good. In Chennai, we saw that it is not possible. Indra Son is actually the creamy layer and 50% cap. Okay, Keswananda Bharti, very landmark case, but did not talk anything about the reservation. Okay, by this we are done with the minority issues. Now let us do the miscellaneous. Okay, first subtopic is MPLADS e-Sakshi mobile application. The MPLADS Member of Parliament Local Area Development Scheme e-Sakshi mobile application was launched by Ministry of Statistics and Program Implementation. Okay, that allows MPs to propose, track, and oversee projects under the MPLAD scheme. Okay, so what is the MPLAD scheme? MPLADs are fund-based scheme used for creation of durable community assets in areas of like drinking water. Okay, so basically forming of durable community assets. Okay, at least 15% of the MPLADs entitlement allocated are for areas inhabited by the scheduled caste population and 7.5% are for areas inhabited by the ST population. So this is important. Okay, in MPLADs, the fund allocation should be such that, okay, if you're building something of a durable asset, then 50% should be for areas where SC stay and 7.5% should be for areas where ST stay. Okay, another very peculiar thing about the MPLADs is the funds are non-lapsable. Okay, what it means that if money is not utilized, it gets carried to next year. Okay, also the district authority must inspect at least 10% of all work under the implementation every year. Okay, so this is some important part. So under which ministry is the MPLADS? MPLADS under which ministry? Ministry of Rural Development, Ministry of Finance, Ministry of Statistics and Program Implementation, or Ministry of Panchayati Raj? Yes, anyone? What is the correct answer to this?
Option D.
Option C. Okay.
D.
No, it's not. It was under rural development first. Don't get confused, okay? But later, now it is under Ministry of Statistics and Program Implementation, okay? Remember this. Okay. So now what else can you study? You can study MPLADS with MLA lads. Okay, how we have MPLADS for the member of parliaments, we have something called as MLA lads also for the member of legislative assemblies. Okay, next subtopic is criminal defamation. About criminal defamation. So as per the Black's Law Dictionary, defamation means the offense of injuring a person's character, fame, or reputation by false and malicious statements. Okay, false and malicious being the keywords over here. So the defamation is categorized into two types. First one is written or libel, and second one is oral or slander. Okay, libel is an untrue defamatory statement that is made in writing. Okay, slander is an untrue defamatory statement that is spoken orally. So according to Indian law, libel and slander both are considered to be criminal offenses. Very important. Okay, to be considered defamation, such statements must be made publicly. Okay, so this is important. It should be made publicly. Personal level pe if somebody is talking, that is not defamation. Okay, understood the two types also. There are two types. One is written, one is oral. and both are criminal offenses in India. So the IPC section 499 makes it unlawful to communicate any false information about an individual to harm their reputation. Okay, and the punishment is 2 years according to IPC. But however, section 352 of the BNS. Yes, do you have a doubt? Dear Siddesh, can you please mute your mic? Okay, so according to BNS, whoever defames another shall be punished with a simple imprisonment for a term which may extend to 2 years, or with a fine, or with both, or with community service. Okay. So the like we saw in the last classes, there are some changes with respect to the BNS. The Supreme Court of India in Subramaniam Swamy versus Union of India upheld criminal defamation, balancing free speech and the right to protect reputation. Okay, so since we have the right to free speech, it does not mean that we can just talk any nonsense about anybody else. Okay, the Law Commission has also said that the reputation is protected by Article 21 because freedom of speech should not be used to harm other feelings. Okay, Article 19(2) also it gives some restrictions on the freedom of speech, of which one is defamation. Okay, this forms a very important part of our prelims study. The next topic is corruption's perception index, CPI. So India is ranked 93 out of 180 countries on corruption perceptions index. So India was ranked 85 in 2022. It is released by Transparency International, and the ranks countries and territories by their perceived levels of public sector corruption on a scale of 0 to 100. If you get 0 score, that means highly corrupt, and 100 means very clean. Okay, so Denmark was ranked first, followed by Finland, New Zealand, and Norway. So the Scandinavian countries are doing better in this. So what is important here? CPI is given by who? Transparency International. Okay, remember this. The corruption perceptions index is given by which organization? World Economic Forum, Transparency International, World Bank, or IMF? Yes? Who? Who gives it? What is the right answer? Anyone?
Option D, madam.
Anybody else? Come on.
Option B.
B. Okay? The Transparency International. So you get such questions sometimes in UPSC. Okay. Next subtopic is SR Bommai judgment of 1994. So what was this judgment? So in 1989, the central government dismissed the SR Bommai's government in Karnataka. Okay, under the article 356. 356 is President's rule. Okay, so a 9-judge bench of the Supreme Court interpreted Article 356 of the Constitution to define the contours of the proclamation of President's rule. So this was that judgment. So the SR Bommai government was dismissed when there was a President's rule. State emergency is also known as President's rule or constitutional emergency. However, the Constitution does not use the word emergency for this kind of situation. Okay. Article 356 finds inspiration in Section 93 of the Government of India Act 1935. Okay, so what are the grounds to declare a president's rule? Based on the report from the governor of the state, or otherwise if the president is satisfied that a situation has arisen in which the government of a state cannot be carried in accordance with the provisions of the constitution. So ek to the governor can give a report, otherwise the president for himself is satisfied. Okay, so what is the validity? The president's rule is valid for 2 months unless parliament extends it for up to 6 months. Okay, extensions beyond a year are only permitted in national security emergency, or if the election commission certifies that holding assembly elections is difficult. Okay, so here important again is parliament, as in both the houses. Okay, so what is important here? All the emergencies, we talked about this in some previous class of ours. Okay, so go through that emergencies. And what else? Suppose you get this SR Bommai case is related to which constitution provision? Okay, which provision? Article 14, Article 356, Article 324, or Article 280? Yes, SR Bommai is related to which constitution provision?
Article 356.
Yes, very good. Okay, so you understand the emergencies, there are differences. Okay, next subtopic is digital criminal management system. So this is launched by Ministry of Home Affairs, designed by the NIA. Okay, we've done NIA also. So what is it? It is a user-friendly and easy to deploy, customizable, browser-based software to help state police forces in their investigation and prosecution. So basically, it's a database. Okay. So what is the significance? It enables NIA personnel to better coordinate in terrorism and other organized crimes. Okay, it will assist state police forces in organizing, integrating, digitizing everything. Okay. So what is important over here is digitalization of criminal data. Okay, with that NIA is also important. So study about this. Okay, remember this CMS. Okay, the Ministry of Home Affairs has also launched a Sankalan app, which is a compendium of new criminal laws by National Crime Records Bureau. Okay, NCRB. It is designed for navigating through criminal laws as a bridge between old and new criminal laws. Okay, so now we have a change of criminal laws. So now this app is there for that ease of navigating through. Okay, suppose some old IPC section is now changed, right? So IPC to BNS, that bridge is been made easier by the Sankalan app, which is launched by Ministry of Home Affairs. Okay. Next subtopic is role of civil servants in governance. So about civil services. Civil servants are permanent officials in the executive wing of governance. Okay. So what is the genesis? The concept of merit-based modern civil services in India was introduced in 1984, following the Lord Macaulay's report. Okay. So post-independence, the civil services are categorized into 3 types. First of all, we have the All India services. Okay. Then secondly, we have central services. Central civil services. Third, we have state civil services. Okay. What is meant by all India services? They are common to both center and states. Then we have central civil services, wherein they work for the central government. Okay, like IRS, example, revenue services. Then we have state civil services, wherein they work for the government of state. Okay. So what are the constitutional provisions related to civil services? Article 310, wherein a person in civil service of the India holds office during the pleasure of president, and every member of the civil service in the state holds office during the pleasure of governor. So this is important. The service matters of the civil servant. Okay. Article 311 talks about the dismissal and removal of the civil servant. And Article 312 talks about the establishment of all India services. So this is important with respect to our special powers of Rajya Sabha. Okay. So what are the initiatives to improve the functioning of civil servants? We have Mission Karma Yogi, which is for capacity building of the civil services. Then we have I Got platform, which is an integrated government online training platform. Then we have National Standards for Civil Service Training Institutions and ARAM. Okay, so it is the foundation course for civil servants training. Okay, what else becomes important with this is concepts like lateral entry. Okay, these also are important. Make sure that you read this. Mission Karma Yogi, I Got this particular thing, Aram. Okay, next subtopic is criminalization of politics. So 44% of sitting members of the parliament face criminal charges. Okay, 5% are billionaires according to Association of Democratic Reforms report. Okay, so according to the ADR report, 44% have criminal charges and 5% are billionaires. Okay, so as per the ADR report, 50% of MPs are facing criminal charges are from UP, Maharashtra, Bihar, Andhra Pradesh, Telangana and Himachal Pradesh. Okay, so 50% of these criminal people who are are MPs are from these particular states. Among sitting MPs with criminal charges, 29% face serious criminal cases, including allegations of murder, attempt to murder, crime against women. So they have serious charges also. Okay. So what is meant by criminalization of politics? It refers to infiltration of criminals, lawbreakers, and corrupt individuals into political system. Okay, who then influence their who then use their influence to further their own interests. Okay, at the cost of the country. So we have criminalization of politics and politicization of criminals. So both are important. Okay, so what are the Supreme Court judgments to curb criminalization of politics? First, we have the Lily Thomas versus Union of India, wherein MPs and state legislators convicted of crime with a minimum sentence of 2 years imprisonment would cease to be members of the house. Very important. Okay, so if a person is convicted, okay, if a MP or an MLA is convicted, okay, matlab he is proven that he is guilty, if he is convicted with a minimum sentence, okay, so for 2 years or more, 2 years / more का अगर punishment मिल गया, then uska seat will be gone. Okay. Public Interest Foundation versus Union of India 2018. A person cannot be disqualified from membership in a legislative body on a mere framing of criminal charges against him. Okay, so this also was given that if it is framed, okay, if it is false, then they don't lose the seat. Okay, so which case has made it mandatory for political parties to disclose the criminal background of candidates? Okay, the answer is the ADR case. Okay, these cases are also important. The next subtopic is internet shutdowns. So what is the provision of internet shutdown? So suspension of telecom services, including internet shutdown, is governed by temporary suspension of telecom services, public emergency or public safety rules of 2017, notified under the Indian Telegraph Act. Okay, so this is the basis for internet shutdown. So what it does is it provides for a temporary shutdown. Okay, in case of public emergency, up to 15 days at once. Okay, the orders of temporary suspension of telecom services are to be issued by union/state home secretary only. Okay, so under the 2017 rules, a 3-member review committee headed by cabinet secretary at central level and chief secretary at state level reviews these shutdowns. Okay, so the review is also done. Okay, but you should remember that both the state and union, as in the center, can order for a temporary shutdown, but it should be issued by the home secretary. Okay, that is important over here. Okay, now what else becomes important with this? Right to internet access. Okay, this is important. Next, we have the World Press Freedom Index. India is ranked 159 among 180 countries in the annual this index. Okay, it is released by Paris-based Reporters Without Borders. Okay, it is published on World Press Freedom Day, which is 3 May. Top rankers are Norway, Denmark, and Sweden, the Scandinavian countries. It is based on 5 indicators: political, economic, legislative, social, and security. Okay, and India has a very low ranking. So what else is important with this? This association. Okay, it is a Paris-based association. So who gives the World Press Freedom Index is given by who? World Bank, Reporters Without Borders, or UNESCO. Okay, or IMF. Yes. Who gives World Press Freedom Index? Anybody?
Option B, madam.
Okay, very good. Next subtopic is special packages. So special packages for both states, Bihar and Andhra Pradesh, were announced in the union budget. So what is this special package? Special packages refer to financial assistance and other benefits to states facing geographical and socio-economic challenges. Okay. So does it have any constitutional backing? Yes. Article 371A to H has provisions address issues of specific states. Okay. But the special packages are purely discretionary and they are on need based. Okay. So in additional grant under the article 282, we have discussed this also in our previous classes. Okay. Do refer to that. Discretionary grants, which empowers both the center and states to make grants for any public purpose, even if it is not within their respective legislative competence. Okay. So what is important? The economic packages in the budget. What else is important? This particular article of discretionary grants and this provision for specific states. Next subtopic is common service centers. So what is this CSCs? It is one of the three pillars of the National E-Governance Plan. Other two pillars are connectivity and National Data Bank. Okay. So what are CSCs? They are front-end delivery points for government, private and social sector services to rural citizens of India in an integrated manner. Okay. So they are at the front end of the services of different services. It is a pan-India network catering to regional, geographic, linguistic, and cultural diversity of the country. So there are certain services offered by the CSCs, which include G2C, as in, so they have different services. Okay, like they have G2C, G2G, G2C, then G2B, B2C. So what is this basically? G is for government. Okay, then C is for citizens. B is businesses. So in G2G, what do you understand by G2G? Government to government. Okay. What it happens if there are some intergovernmental facilities, if something has to be done between the government. So then that time they use G2G. When G2C, suppose government is giving some facilities to the citizens. For example, Aadhaar. Okay, we've all been to the Aadhaar, those CSCs for Aadhaar. So we go there. That is the front end delivery point. Okay, then we give all our biometrics and everything, and then we get the Aadhaar card. Okay, so that is a G2C. Then we have G2B for businesses. Okay, then we have B2C. B2C as in from business to the citizens. Okay, or the customers that we have. What are the B2C examples? Like Bharat Bill Pay, mobile and DTH recharge. Okay, so if you visit any CSCs, they sometimes give us DTH recharge services also. Okay, so it is basically for undertaking all the financial services and also social sector services. Okay, so it is one of the pillar of the National E-Governance Plan. Okay, this is a part of the Digital India mission. Okay, hence CSC also come under Digital India. So CSC bridge divide the digital divide, bridge the digital divide. Okay, by providing access to online services in remote areas. Okay, what else is important? CSC 2.0 scheme is also been launched. Okay, which is to set up at least one CSC in each of the 2.5 lakh gram panchayats across the country. So the common service centers, CSCs, are a part of which mission? Make in India or Atma Nirbhar Bharat, Digital India, or National Health Mission? Yes, anybody? What is the correct answer?
Atmanirbhar Bharat.
Yes, anybody else? Quickly.
Option B.
We just talked about it, no?
Option B.
Option C, Digital
C,
India.
C.
Okay?
Okay. Okay, madam.
Yeah. Okay, remember CSCs. They are the common service centers, basically giving you services. Okay? The internet services, basically. The next subtopic is Sampurnata Abhiyan. So the Niti Aayog has launched Sampurnata Abhiyan, which is a 3-month campaign to achieve saturation of 6 key indicators in the aspirational districts and 6 key indicators in the aspirational blocks. So what is this aspirational districts program? Okay. So aspirational district, this particular scheme has the goal to transform the 112 most underdeveloped districts of our country. Okay. Aspirational blocks has taken influence from this aspirational districts program, and now it has on the same basis. So we'll see the key differences between them. So the districts program was launched in 2018, the blocks program in 2023. Okay, what is their aim? Districts is to quickly and effectively transform 112 districts across the country, and this is services in 500 blocks, which is about 329 districts across the country. So what are the focus themes in district program? It is health and nutrition, education, agriculture and water resources, financial inclusion and skill development, and infrastructure. In the blocks program, we have nutrition and health, education, agriculture and allied services, basic infrastructure, and social development. Okay. So how is the measurement done of progress? In districts, we have 81 indicators, and in blocks, we have 40 indicators of development. Okay. So this aspirational districts and aspirational blocks. This scheme is important. Who has launched it? Niti Aayog. Okay. And also Niti Aayog has launched the Sampurnata Abhiyan also. Okay. For the campaign. Any doubts? Anybody?
No, ma'am.
Okay. So I hope that you are liking this video. And if you like this initiative, please like the video and subscribe to our YouTube channel. Also share this with your friends who are preparing for UPSC prelims. You can find the PDF of this current affairs in our Telegram channel. The link will be provided down below. Okay. Thank you. Thank you very much.